Hello, everyone. My name is Arya Javidan, and I'm the project manager for the National Consortium of Telehealth Resource Centers. Welcome to the latest presentation in the NCTRC webinar series. Today's session is on what will 2024 bring for telehealth policy, and it is hosted by the Center for Connected Health Policy. These webinars are designed to provide timely information and demonstrations to support and guide the development of your telehealth programs. Just a little bit of background on the consortium before we get started today. Located throughout the country, there are 12 regional telehealth resource centers and 2 national, one focused on telehealth policy and the other on telehealth technology assessment. Each serve as focal points for advancing the effective use of telehealth and supporting access to telehealth services in rural and underserved communities. A few tips before we get started. Your audio has been muted for today's webinar. Please use the Q&A function at the bottom of your screen to ask questions. Questions will be answered at the end of the presentation. Please also note that closed captioning is available, and that's located at the bottom of your screen. Today's webinar is also being recorded, and you will be able to access today's and past webinars on the NCTRC YouTube channel. And with that, I will pass it over to today's speaker, Mei Kwong, Executive Director for the Center for Connected Health Policy.
Thank you, Aria. And if you just give me a second while I start to share my screen here. Thank you, everyone. Happy New Year. Hope everyone is doing well. And if you are being hit by storms, that you're staying safe and warm as well, too. First off, thank you to the consortium for inviting me to do this webinar today. Before we get started, a couple of quick disclaimers that I need to make. Please know that any information that I provide in today's talk is not to be regarded as legal advice. It is strictly for informational purposes. CCHP always encourages you to speak with legal counsel if you are interested in formal legal opinion. And also note that if I happen to mention a product or a company or show a picture of one, know that neither I nor CCHP has any type of relevant financial interest, arrangement, or affiliation or relationship with such a company. Quick background on CCHP. If you're not familiar with us, we were established as a program underneath the Public Health Institute in 2009 to actually really be a California telehealth policy organization. An opportunity to become the federally designated National Telehealth Policy Resource Center became available in 2012 through a grant from HRSA. CCHP applied for that and we got it, and we've been serving in that capacity ever since. We also work with a variety of other funders and partners on the state and federal level. Some of them include the other telehealth resource centers. So we, CCHP, actually act as the administrator for the National Consortium of Telehealth Resource Centers. If you have not engaged with your regional telehealth resource center, I highly encourage you to do that as soon as possible. They are a wealth of information and resources for you. I always say they are the smartest people, or some of the smartest people in the country today regarding telehealth in all aspects of it, from where you get started, what it is, how you use the technology, what is the technology, to policy issues as well too. So again, if you have not interacted with your regional telehealth resource center, I highly encourage you to do that. CCHP also convenes a group in California. For those who are, again, not familiar with us, we are located in the state of California. So we also convene a group called the California Telehealth Policy Coalition, which is made up of over 175 state and now national folks as well, too, who are interested in California state telehealth policy. So for today's webinar, I'm going to provide you an overview of the federal and state telehealth policy landscape, what we have and what we know right now on January 18th, 2024, where we are with our telehealth policy, because over the last couple of years, it's been kind of a moving target of sorts, especially on the federal level, just because of the temporary policies that were put in place because of the pandemic. So we're going to talk about exactly where we are today. I will warn you, it is likely going to change, or things are going to happen throughout the year. But just to give you sort of a grounding point for 2024, we'll also talk about what is going to possibly happen in the future and what we need to keep an eye on and where things may go. I do want to stress that this webinar is not to be used for specific billing questions. So we're just talking about the general policies regarding to reimbursement underneath Medicare, and I'll touch slightly on some of the Medicaid policies in general that we're seeing throughout the states. But for your specific billing questions, I highly encourage you to contact your regional telehealth resource center, or you can contact CCHP directly. If you do not know who your regional telehealth resource center is, please go to the consortium's website that ARIA has, provided information on, and you can locate the TRC that covers your state. And also, when you submit your questions to the Telehealth Resource Centers or to CCHP, if you can provide as much information as possible, particularly the type of entity that the question applies to, whether it's a hospital or a private practitioner or a federally qualified health center, et cetera, that would really help us a lot, and it'd be able to help us get your answer more quickly to you. Because depending on the type of entity or organization you're talking about that your question involves, the answers might vary. So it might be a little bit different for a private practitioner as opposed to what a federally qualified health center might experience in that situation. So without further ado, let's get into it. So keep in mind that while we're talking about telehealth policy, we are talking about two distinct and different jurisdictions. You're talking about federal and state. And sometimes the policies may mirror each other, but more often than not, they don't necessarily. And there's also separate areas or separate issues that the federal policy might cover that the state policy doesn't really touch, or they touch a different aspect of it. So these are kind of the major issues that I'm going to touch upon today. These are by no means the only issues, but quite frankly, if I were to try to cover everything that's going on out there, we'll probably be here for a couple of hours. And I really don't think anybody wants to listen to me for that long. So we're just going to hit on sort of the major issues that are in question right now, or that we're going to be discussing for today. So underneath federal policy, that's Medicare and CMS, prescribing controlled substance, HIPAA, privacy and data, and licensure. And underneath state policy, it's Medicaid, private payers, and prescribing and licensure. Now, you're going to see, again, some issues seem to cross both federal and state. And that is because there may be certain aspects of the policy that's underneath state control and other that's underneath federal control. And then some where there may be policies going on or actions going on that could reverberate over states that may be happening on the federal level. So let's get into exactly the things that influence or impact policy in general. So when you talk about how telehealth policy is built, there's actually 4 main sources of information to keep an eye on. Laws and regulations, most people are familiar with, but there's also 2 other areas, guidances. And when I talk about guidances, I mean, these are things that are not laws or regulations that perhaps an administering agency issues. So they may be, for example, guidances that the Office of Civil Rights, which oversee HIPAA, issues to the general public about things such as, these are things to consider if you are talking about using audio only that relate to privacy that, providers should keep in mind. So they don't have the force of a law or regulation, but it kind of gives you an idea of oh, this is what that particular administrating agency or oversight agency is, how they're looking at that situation. I should probably align myself to what they're suggesting here, because if they then decide to enforce something or come down and, look more closely at someone, this is probably where the areas that they're going to look at and, how they're probably going to judge you. So guidances are important to get that extra information that may not necessarily be present in laws or regulations on the thinking of the administrating agency and how they may approach a particular policy. Now, court cases, that doesn't, I think, make it to a lot of people's radars initially, because they may not think, what are the impact of court cases on telehealth policies? Because, it would be legislative members or congressional members passing laws. That's what would have the biggest impact. Well, court cases do have a lot of impact because they may be taking those actual laws to court and saying these are unfair laws, or these are laws that violate, a higher law such as a constitution. And we'll get a little bit more into that, because particularly in 2024, that is going to be very important to look at and monitor. And as I mentioned a second ago, we'll go into a bit more detail on that later in the presentation. So let's start off on the federal level. And we're going to start off with CMS and Medicare, which is really basically about reimbursement and coverage. Now, where we were with CMS's telehealth policy is that pre-COVID, it was fairly limited. So those who may not be as familiar with the telehealth policies in Medicare before the pandemic hit, it was pretty restrictive. And the reason it was pretty restrictive is because a lot of those telehealth policies are embedded into federal law. So they hadn't really been changed over the time that they have been introduced, and they were introduced back in 1997. So it's been a while since the telehealth policies and law had been changed. There have been tweaks made over the years, but essentially they remained unchanged from around that 1997-2000 type of period. So they were very limited, such as the patient needed to be in a specific type of location, both geographically and the type of site they were in, like the type of building that they were in. There was like a limited amount of providers that were eligible to provide those services and still be reimbursed by CMS underneath the Medicare program. And you were limited by the type of modality that could be used to provide these services. So that's your pre-COVID telehealth policy in Medicare. Again, as probably most of you are aware, during the pandemic, that changed drastically. There were a lot of waivers put in place where they opened up those limitations and they waived them and said that we're not going to, restrict where the patient's located. We're not going to require this geographical requirement be met during the pandemic. So a lot of those were waived. And the question then became last year with the public health emergency winding down, well, what's going to happen to these temporary policies? And for the most part, what we have post-pandemic and going until the end of this year is pretty much the major policies are sticking around. The major policies are those waivers that were done into the policies that were embedded in the law. So patient location, the type of providers who are able to provide it, the modality limitations. So we'll take a little look at that a little bit more deeply. As I said earlier, it's like waiver geographic requirement, the eligible providers. Now that eligible provider list, again, very limited list underneath permanent policy, opened up to eligible Medicare providers during the pandemic, and that's being kept around. And that included federally qualified health centers and rural health clinics and professionals such as PTs and OTs. So again, that's sticking around until the end of this year. The site limitation need to take place in certain type of facilities, such as, a hospital or a doctor's office or a clinic. Again, that's opened up. So that's opened up the home as well too. Underneath permanent policy, there are some exceptions where they allow certain services to take place in the home. During this sort of temporary grace period until the end of 2024, that's open up to all eligible services as well too. And then allow some services to be provided via audio only. They're going to continue with that as well. The expanded list of eligible services to be provided via telehealth, that's always been limited, and that's not necessarily limited by law. So law has sort of a base level of like what services need to be covered if they're provided via telehealth, but that's always been more under CMS's control. So they haven't had to really wait for Congress to approve new services, but they do have their own process on what they approve as far as what services can be done via telehealth and get reimbursed. So that varied a little bit from what we saw in the pandemic, but for the most part remains intact until the end of 2024. Some services have dropped off and some have actually been made permanent, put on the permanent list. So it's fairly intact from what we saw during the pandemic. But again, there are certain services that unless something changes, once it hits January 1st, 2025, they will go away. Other things that were waived during the pandemic, but will remain until the end of the year is, and this was a big one, the provider using their business address rather than putting their home address. So this is more of one of those kind of tricky administrative things that aren't necessarily directly related to telehealth, but has an impact on telehealth. So providers that have to put onto their forms the address of where they are primarily doing their services. And if they're doing them primarily from their home for telehealth, they have to put that address. Well, sometimes that data is publicly accessible. So those providers, were worried of like, well, I don't want to put my home address on this. So there was an exception made during the pandemic because there were a lot of providers moving to the home to do their practice, or doing it partly from their home as well too. That CMS said like, well, you can put your usual business address on there as well. They've kept that policy at least through the end of 2024. And this was actually a policy that kind of went back and forth because initially when CMS came out in the spring, right before the end of the PHE, they were saying like, this is going to expire. And then they changed their mind. They said, well, we'll extend it until the end of the year. And now they said, well, we'll extend until the end of 2024. So CMS last year, after a little bit of back and forth, really were aligning a lot of their policies to that end of 2024 date. And the reason for that is why 2024 is like that magic date is because that's what Congress decided back in 2023, with their Consolidated Appropriation Act in 2023, they decided to extend things out into 2024. So that's not CMS making that decision on that date. That's actually embedded in federal law because it was in a congressional bill that was passed and enacted in law. It's actually the appropriations bill. Waiving of frequency limits on telehealth visits in SNFs. So the permanent policy, which was changed during the pandemic by CMS, is that telehealth visit every 14 days. They waive, before it was like a telehealth visit every 30 days. They waived the frequency limit in general during the pandemic, and they kept that policy, again, aligning it to that 2024, end of 2024 expiration date. And then there were other things such as allowing for direct supervision to be done via telehealth. Again, this is one of those policies where it was a little bit broader during the pandemic, and they've like kind of narrowed it down or only allowed it for specific things. So they've reined the TAC, for example, if you're doing supervision of residents when the service is furnished virtually. If the service is furnished in person, the residents furnishing that in service in person, you can't use telehealth to do the supervision. So that's a good distinction there too. This is just an overview. There is a lot more sort of nuanced or specific types of policy changes as well. So I highly encourage you to look at CCHP's 2024 physician fee schedule or look at the full final schedule itself. And then there are a couple of other resources here that I put, such as the CMS telehealth fact sheet that they did that was issued in December of last year. So it's fairly recent. All right. Moving on, prescribing of controlled substances. So you'll see that I have prescribing both on the state and federal level, and that's because it is split between the state and the feds. So prescribing of drugs, controlled substances, it's underneath federal jurisdiction. Prescribing of everything else that's not a controlled substance, the states can oversee that as well. So what we have on the federal level is actually policy, again, that existed before the pandemic. You'll hear a lot of telehealth people say like, oh, it's the Ryan-Haight Act. It's because that was the federal bill which the telehealth section was under. So that's like the shorthand for a lot of telehealth policy folks when they talk about telehealth being used to prescribe a controlled substance. So there were limited exceptions in that policy, and that's now in federal law, on how you can use telehealth to prescribe a controlled substance. And they're highly specific, and they usually include essentially the patient being somewhere or with someone who's also a DEA licensed provider. And during the time that they're interacting with the telehealth provider who's also DEA licensed. One of the exceptions that was in there is when a public health emergency is declared. So when the pandemic hit, the COVID-19 pandemic hit, that exception automatically kicked in. So a lot of people think, oh, well, Congress did something. No, they didn't. It was already in federal law. It's just sort of an automatic switch that happened. So that was why there was like a lot of concern of like, okay, what's going to happen next? Are we just going to go back to this, oh, just limited exceptions once the public health emergency is declared over, or is some other action going to be taken? Well, what happened was, for those who may not be familiar, when the public health emergency was winding down for its sort of declaration to be over in May of 2023, a couple of months before that, federal agencies were prepping to get ready on what would happen after the public health emergency. CMS was doing that, and DEA, which oversees this particular policy, they were doing it as well. And what they did was that they issued post-PHE regulations where they said, this is what the landscape's going to look like right after the public health emergency. They were not met with a lot of enthusiasm. So what happened was, and just really roughly, basically they said that we were going to essentially go back to the pre-COVID-19 situation, they were going to create essentially one other exception, and then they were going to create like all these other new requirements that were going on as well too. They gave like a little bit of a temporary extension for folks, but they're essentially saying like it's going back to pre-COVID type of situation. And that was not met with much enthusiasm by a lot of people. So they received over, I think it's close to 38,000 comments, which they in no way were going to be able to get through by the time that they would have to finalize these. So what the DEA said was, okay, we're going to create a temporary extension. The COVID-19 temporary waiver type of situation, we're going to allow to extend out to November of 2023. After that, you know, those who had already established a relationship, you can continue to do things via telehealth. Everybody else, you're out of luck. But by the way, those who established a relationship, you can continue to do things, but you're going to need to like see that patient in person. And you have a year to see that patient in person because everything will end on November of 2024. Well, the DEA, people still weren't happy with that. So late last year, around September of last year, the DEA held listening sessions from the public at the feedback of 2024. The DEA came out and said, like, you know what, we're just going to extend this COVID exception until the end of 2024. Again, aligning up with that end date of December 31st, 2024 that we saw with the Medicare policy. So on the federal level, you're seeing this alignment from all these different agencies of, well, we're going to allow these temporary things to continue, but come December 31st, 2024, it's over. Once that passes, it's over. The good thing about this is that what we saw over the course of 2023 is, I think, a more openness by the DEA in listening to things. Because if you compare to what they were offering or what they were suggesting with the proposed regulations back in March of 2023 for what would happen at the end of the PHE, it was very limited. But towards the fall of 2023, they were talking about, you know, like an extension, because things were going to end in November 2023, an extension to 2024. But they were also finally starting to talk about, well, maybe we'll look at the registry idea. Now, you're going to ask, some of you may ask, well, what's the registry idea? In those limited list of exceptions in the Ryan-Haight Act is a registry for telehealth providers, which the concept is the DEA would create this registry. And if a telehealth provider wasn't on it, they were considered a good egg. They've been vetted and everything. They can prescribe a controlled substance via telehealth, and they didn't have to meet one of those other existing exceptions. So, sounds great. That registry was never created. The DEA actually was directed by Congress to actually finalize regulations for the creation of that registry by the end of 2019. Never done. Nothing was even like proposed or sent out. And then COVID happened in the beginning of 2020. And that kind of fell by the wayside. A couple of congressional members, I think Senator Kane was one of them, did ask throughout the pandemic, like, well, where's the registry? You guys were supposed to do this. As early as the beginning of 2023, or as late, however you want to look at it, in early 2023, when people brought up the registry, the DEA did not seem interested in actually doing anything about that. But come fall of 2023, they were talking about it again. So there is like a possibility that they may finally get that implemented and started and like have that process create that. And that will create like another exception on prescribing a controlled substance for telehealth providers. So this is very important to watch because not only, you know, like the CMS policies, not only is there a specific deadline by the end of the year, that the DEA has, but there may be like, you know, a change in what they're going to propose compared to what we saw like nearly a year ago. Well, we're just going to create this really, really specific limited exception, and we're going to add all these other requirements onto your providers that you haven't seen before. So this is definitely something to keep your eye on as well too. And for the DEA, considering how many comments they got last year, like, you know, 38,000, which from my understanding is the most that any agency has ever gotten for proposed regulations. They may feel that they need to start early so they have time to actually go through those, because when you do that regulatory process and you get those comments, they're required by law to respond to them. So to read all. So I don't know if they may do something sooner than perhaps like say CMS or Congress, simply because they may be scared or they may be concerned that they may get like an avalanche of comments again, and they won't have enough time to process them by the end of 2024, the deadline for the temporary policy. Now, HIPAA, privacy, and data. So before the pandemic, HIPAA did not actually really address telehealth. You still had to abide by HIPAA, but there was nothing in HIPAA that said, oh, and by the way, this is what you would do if you're using telehealth. So providers, understandably sometimes, had to really think hard and how they would meet those HIPAA requirements while they were using telehealth, because there really wasn't specific guidance out there on how to do that from federal government. So this is underneath the Office of Civil Rights, OCR. So that's what I mean when I say OCR, they're the administrating agency. During and post-COVID-19, that was when a lot of people realized, oh, well, HIPAA is really outdated for a lot of, technologists in general. So what has been decided on that is that there was a guidance that was issued during the pandemic where OCR would exercise discretion on telehealth technology. So this was issued at the beginning of the pandemic because the realization that a lot of providers were using telehealth for the first time, standing up telehealth programs for the first time, and they were more concerned, OCR was more concerned on those providers actually being able to serve patients. So they were we're going to exercise discretion, kind of, we're not going to ding you if you use a platform that doesn't quite meet HIPAA requirements, because we know you're trying to serve patients. So that was something that they had issued. Again, a guidance. It wasn't regulation. It wasn't statute. This is why I said guidance is really important also to keep an eye on. They issued that guidance, said we'll give you a break during this pandemic. That ended with the expiration of the public health emergency. In the meantime, during the pandemic, the realization hit the federal government that, HIPAA, it's really out of date when you're talking about telehealth. So what happened was the Biden administration, this was, I think, in 2021, issued an executive order saying, you need say HHS, which OCR is underneath, HHS, you really need to look at HIPAA and try to update things here as well in relation to telehealth. That's ongoing. I think I've heard that there may be something coming out this year, but that's an executive order that exists out there. And in the meantime, what we've also seen is that HHS has been issuing a lot of, again, guidances on how does telehealth interact with HIPAA protection of health information. Now, this is not simply just about HIPAA, and we'll talk about it more in a second. It's also about privacy and data too. So there's been a lot about that going on. But I put on here a couple of resources for folks if they have not seen it that they can go ahead and get. Aria does post a copy of my PowerPoint along with the recording after this. So these are all hyperlinked. You just need to click on it, download the PowerPoint, and then click on the links to get to that particular type of guidance here. So as you can see here, there's things around audio only and HIPAA, and then sort of privacy and security tips that for patients that, might be useful for you to pass on to your patients as well. Now, privacy and data. The discussion over the last 18 months, 2 years, have really gone beyond HIPAA as well. There's also been a lot of concerns about privacy and data and how health data is being tracked by certain applications and software. And this has really been, things that are going to impact telehealth that may not necessarily have been on your radar to focus in on. But I'm warning you right now, it's stuff that they are taking seriously on the federal level, on the regulatory level as well too. And this isn't not necessarily has its roots or has its beginnings because of concerns over HIPAA. This is other issues that are impacting telehealth as well too. So it's not necessarily that concerns that sprung from telehealth to begin with, but more sort of other issues and the larger concern over what's happening to this data and the privacy of patients as well too. So what we've seen in 2023 and 2022 and 2023, they did this in 2022, but in 2023, government agencies such as HHS and OCR and the Federal Trade Commission commission issuing warnings about like online tracking technologies and like, what people need to be aware of and like the data that's being gathered and how that data is being used as well too. I put this on here because this may not be like an initial thought that you may have when you're selecting certain software or data to use in your practice. And I just want to say, like, just be aware of it. This is a concern that's been flagged by regulatory agencies on the federal as being like potential issues. They have actually gone after some companies as well for the tracking of data and maybe utilizing it for marketing purposes and not informing patients as well. I'm not saying that providers are doing that, but if you have a contract with a certain vendor who you are using like their platform from, be aware of like how they are, gathering that data. It's just something to keep in mind that I wanted to flag for folks out there as well too, because I just don't see this issue as going going away. So it is probably something that's going to, get a lot more attention and probably more regulation down the line as well too. Licensure. This is going to be the interesting one. So for folks who have listened to me in the past or listened to any policy folks when we're talking about telehealth and licensure, licensure is in the state jurisdiction to control. Feds really don't have any control over it. It's done on an individual state by state level. So each state decides on what it's going to be for their particular state. And roughly what it means is that, if you're going to provide health services within a state's border, you need to have a professional license issued by that state. That's just sort of like the general sort of policy out there. Yes, there are compacts, there are exceptions, et cetera, but the general policy is you got to get a license in another state, and that's decided on a state by state level. So you're probably asking me, well, what does the federal level have to do with licensure? Good thing you asked that. Late last year, December 13, 2023 to be exact, a court case, a lawsuit was filed in U.S. District Court of New Jersey, McDonough v. New Jersey State Board of Medical Examiners. And what the plaintiffs said, the people who filed the case, is said that my constitutional rights are being infringed upon by New Jersey licensure laws related to telehealth. This is major here. So why this is important? One, it is a case specific to licensure laws and telehealth. There have been previous cases that kind of like went around on like the licensure laws and maybe impacts on providers, but there's not been that very specific link in a case, as far as I'm aware, where they said like licensure laws as they relate to telehealth is a problem. The second thing is they make constitutional argument, U.S. Constitution, not the state constitution. So they're making a U.S. Constitution argument. So that elevates it into a federal case here. So this is not a state case then. This is not then a New Jersey case, New Jersey state case. It's an argument about my constitutional rights as a U.S. citizen are being violated. So it's a federal case at this point. And they're basing their arguments on 4 parts of the Constitution, or the Commerce Clause, which also includes Dormant Commerce Clause, Privileges and Immunities Clause, First Amendment, and 14th Amendment due process. CCHP is issuing a newsletter that goes a lot deeper into this. So I'm just going to just go lightly over this as well too. So Commerce Clause is something that like telehealth folks have been talking for a while about telehealth licensure and like what argument could be made on it of saying like, that the feds could have a part on. So the most talked about like argument on like or route of saying like, where the feds can actually have an influence on state licensure is the Commerce Clause. So the Commerce Clause, the theory on that is, and what it says in the Constitution is that interstate commerce is in Congress's jurisdiction to administer and oversee, not the states, because it involves multiple states here. It's not within their borders. So if states do something to mess with interstate commerce, that's a violation, or that's encroaching upon like an area that Congress has oversight on. And then dormant commerce clause is connected to that by saying like, well, just because the feds didn't necessarily do anything about it or say something specific about it, it doesn't mean it doesn't still come underneath their jurisdiction. So that's where that comes in. The argument is that state licensure, individual state licensure interferes with that interstate commerce because now you can have a telehealth provider in another state providing services into that state, but by requiring them to get licensed by that state, you're interrupting that flow of interstate commerce. So it is that specific of like, there's essentially two states involved. So that flow of commerce is being interrupted. That has been the most sort of common theory on how to approach like the licensure issue or to debate the licensure issue as a federal issue. Privileges immunity clause, First Amendment, 14th Amendment, the last two are really sort of unique. Privileges and immunities clause is the, everybody has the same privileges as a U.S., basic privileges as a U.S. citizen, no matter what state they're in. And one of those is to like earn a living, and states aren't supposed to like kind of impede somebody's ability to earn a living just because they're from another state. First Amendment, you're all familiar with this. This is speech. And theory is that because a regulatory agency would need to examine a conversation between a patient provider to determine if health services were provided, that's impinging upon the First Amendment rights of protected speech. And then 14th Amendment due process clause, this one is really interesting. You're all probably familiar with due process as far as like criminal offenses, like we all have due process for committing a criminal offense, but there's also things that apply to civil cases as well. And one of them is like a parent's ability to decide on the education and healthcare of their children. So one of the plaintiffs involved in this particular case is a minor. So his father is making the argument of like, my due process clause, my due process rights are being infringed upon by this licensure law because they are requiring this doctor who is located outside the state of New Jersey to have a license here. So really, really interesting case. It's a major case, again, because it is specific to telehealth and licensure. It was just filed December 13th, 2023. So there's no news on that. New Jersey has until mid-February, I think February 16th to file their response. Definitely something to keep your eye on. And also, keep your eye on New Jersey legislation. So what the state could do is possibly pass legislation that kind of addresses some of these things. And then they say to the court, like, well, this case has no bearing anymore because we passed legislation to do X, Y, and Z to address like the plaintiff's concerns. So this is new and developing here. Definitely something to watch. It is a court case, so it may move kind of slowly. But even if a decision is rendered, there's always an appeal process. So this could take a bit of time, but definitely a big policy development. Okay, we're getting into states, and I know we're starting to get short on time. But because all the states are really different and everything, I can't go into too many details about specific states. I highly encourage you to go to the CCH website and our policy minder, because we do state tracking on policies for Medicaid and in their laws and regulations as well. So to go there if you're interested in a specific state policy. So this is just going to be like a general overview that we're going to have. So Medicaid and private payers. Really what we have right now are, as of the around October, late fall or fall of 2023, is that all states and DC reimburse for live video. We were not able to find in their Medicaid program, we were not able to find that for Puerto Rico and the Virgin Islands, but definitely in the US states and DC, there's some reimbursement for live video and Medicaid. In the Medicaid program, 33 states reimburse for store and forward. Keep in mind, it may only be for a communication technology-based service, like, for example, like an e-consult or one of those other codes as well. It may not necessarily be, a full-blown sort of store and forward of any type of service here. And then 37 states have some reimbursement for remote patient monitoring. The interesting thing is that 43 states now have some reimbursement for audio only in their Medicaid program. And this is where the huge shift in policy came from. Before COVID-19, I would say only a handful of states have had this, and they were very hyper specific. They would be situations such as for targeted case management. You now see 43 states have that reimbursement policy for something. And a lot of them do include it underneath the umbrella of telehealth. Before the pandemic, that would not have happened. For private payer laws, 43 states, DC, and the Virgin Islands have some form of private payer laws. Keep in mind, those laws vary in what they do. They can be all the way from a law that says a private payer may cover telehealth if that plan wishes to do so, all the way to a state that mandates that coverage and also mandates parity of payment. So there's a wide range in exactly what those policies look like. Again, it's going to be very state specific. You will need to look at that. All of these policies, these are just general numbers here. All of these policies have exceptions, limitations, etc. So it is very important to look at each state's policies for something that you're interested in, because it will vary from state to state. Prescribing. Now, as I mentioned earlier, all the other stuff for prescribing that's not controlled substance, it falls to the state to have control over. So how they do their policies around telehealth is usually starts with like how you establish that patient-provider relationship. Would you need that in-person visit before you can prescribe? And for the most part, the states say like you can do that via live video. There are some exceptions to that. Like if you're talking about a certain type of medication, they may require like an in-person visit or have some sort of policy that makes it a little bit more difficult to use telehealth. There are also a few states that have exceptions to allow that patient-provider relationship or prescribing to be done asynchronously. That's kind of rare though. So again, you'll have to look up the state. For the most part, it's like you can establish a patient-provider relationship, but it's got to be via live video. Just a handful of states allow asynchronous, it's not that many. There's also limitations that states may impose on prescribing, and those are related to abortion-inducing drugs, vision and hearing. So prescribing contact lenses or prescribing a hearing aid, there are some states that have limitations on how you can use telehealth to do that as well too. And also for marijuana and also renewing of marijuana prescriptions, again, limitations on how telehealth may be used or not be able to be used. And usually what you'll see for a lot of states is also language of like, meeting all state and federal requirements related to prescribing. So that involves the controlled substance area as well. Licensure, I talked about earlier, it's underneath the state's control, at least for now. We'll see what happens in that court case. For the most part, what states have been doing over the years in addressing the telehealth licensure issue is to try to do compacts. There are, I think at this point, probably close to a dozen different compacts, and they're based by profession. So you have a physician's compact, you have a nurse compact, you have a PT compact, you have an OT compact. So there's not like, a telehealth compact for all healthcare professionals. It is done by individual health profession, and they're all structured differently. So for example, the physician medical licensure compact is not a one license practice in multiple jurisdiction. It is a license, and you are allowed to go through an expedited process to get another license in another compact state. But then you compare it to like the nurse licensure compact, which is, it is one license, you practice in multiple jurisdictions, like you can practice in any of the other compact member states. So it's important also to keep in mind like what compact you're talking about and what they've agreed to do and allow for that practitioner. Another area what we've seen, or another way for states to address the licensure issue, has been through registries. This kind of started off, I don't want to say hot, but we saw a lot more activity around registries, creation of registries in the states more towards the beginning of the pandemic or the early first or second year of the pandemic. And we kind of haven't really seen a lot of that in the last year or two. And what these are is the creation of a registry by the state that says, if you get on this registry, you're a good egg, you don't have to get a license. Florida has one, for example. They were actually one of the first ones, but I think only one or two other states have done this as well. It's not something that's been kind of had the amount of popularity, for example, as compacts has. We've also seen states doing limited exceptions. So if there was, for example, they may say, well, if you've had like a prior established relationship, we're going to allow you to practice in our state without like getting a license. If it's somebody who just moved here from the other state, we'll give you like a 30-day grace period until they can like find a new doctor or something. Or if it's something like, you know, oh, it's a student that's moved into our state for school or something, then you can like have a limited number of interactions and then we're not going to require a license. That also goes to infrequent interactions. So these are exceptions that, you know, states have been carving out over the last couple of years too. And also another exception is contiguous state exception. If you're from a certain amount of distance from the borders between states, they'll allow it. Or they've come to like an agreement between certain states. For example, DC, Maryland, and Virginia came to an agreement last year that they would, you know, allow for exceptions on licensure, just because for those who are familiar geographically with it, you're really close. They're really close. And you have people daily just like going in and out of like the different jurisdictions. So they've like done some licensure exceptions last year as well too. So that's where licensure is. Could this all change with that court case? Definitely. We'll have to see how that court case goes. But again, I caution you, that court case was just filed last year in December. It is far from like a done deal and everything. They have to actually like try that actual case. Decision has to be made. There may be like, you know, an appeal afterwards by whatever party loses. There could be changes to it because maybe the New Jersey legislature does something to like address the issue and then the case gets, you know, thrown out because there's no longer like casework because New Jersey maybe changed laws to address plaintiffs' concerns. So that's still unsettled here, but we'll see what happens over the coming months. What to look out for in 2024 on the federal level. They got to make some decisions. Time is running out. Things will be expiring by the end of this year. So what we need to see is what are they going to do with the temporary Medicare policy and the prescribing of controlled substances. People always ask me, hey, what's the chance of a telehealth bill getting passed? And my honest opinion is I don't think a telehealth standalone bill has much of a chance. What they've done over the last couple of years is to put telehealth policy changes into a larger bill, usually an appropriations bill. For those of you who track what's going on in the federal government, we don't have an appropriation bill right now or a budget bill. They're talking about doing another continuing resolution to go out into like March. That's what they're working on right now. I don't expect any policy changes in that continuing resolution. It's going to be in the big bill. If they put any policies in to change telehealth or address like the expiring deadlines, it would be in like the big bill, would be my guess, and not necessarily a standalone telehealth bill. Doesn't mean a standalone telehealth bill wouldn't happen. It definitely could happen. I'm just saying the last couple of years when they've done telehealth policy changes, it's been in those larger bills as a feature of it. DEA, they'll probably go the regulatory route. They're not going to wait for Congress here. So that's going to be like another thing to keep your eye on is that regular changes. For those who are familiar with it, there is the physician fee schedule, but a lot of these things are statutory changes that need to be made. So really CMS's hands are tied. They may not be able to go through the physician fee schedule process to be able to change this. That's their regulatory process. They really will have to wait for Congress to decide. There supposedly is a HIPAA update later this year, so keep an eye on that. AI. A lot of people are always asking about AI. It's a big topic of conversation. There's not really any policy around. There was an executive order from the White House on AI. The NIST drafted guidance, a privacy protection technique for AI. This is a developing area, so I don't really have much to say about it just because it's being developed right now, but definitely something that we all need to keep our eye on. And then broadband, the Affordable Connectivity Program. Technically, the funding for that has run out. So the FCC had said a couple of weeks ago that they were working on winding down that process or that program because there wasn't any more funding for it. But there has also been in recent days congressional members saying like, no, we want to continue funding this. Again, but we don't have a budget bill right now though. So, but there seems to be bipartisan, I would add, will on continuing that program. So we will need to keep an eye on that and see, you know, what happens with it. On the state level, Actually, a lot of states have really settled on what their post-COVID policies for telehealth are, at least as far as like, what temporary policies carry over into the post-PHE environment. However, what we've seen with a lot of states, an interest in increasing data collection and the efficacy of telehealth and examining that, definitely in their Medicaid program. So that's something to keep an eye on. There are also some temporary extensions in certain states, like for example, Maryland and Connecticut extended their telehealth policies that were in the pandemic to a future date, sort of like what Medicare did as well. So keep an eye on those states if they are related to you, are of interest to you, because they're in the same position as the federal government that they're going to need to address what's happening with those temporary policies soon. And in areas for further development discussion, people are talking about, expanding telehealth use in Medicaid, the licensure prescribing that we covered earlier. But the big thing that's probably going to influence some of this going on, especially when you're talking about Medicaid, a lot of states are experiencing budget shortfalls. So if you're talking about expanding telehealth in the Medicaid program or keeping around these temporary policies, the fiscal people in those states are going to see that as more cost to the state. And if they're experiencing a budget shortfall, there may be more resistance to expanding those policies. That's also something that's going to be faced on the federal level as well, too. You've got a lot of like budget hawks out there that are looking at the federal budget and not wanting to necessarily expand. So budget shortfalls do play into everything, the policies on the federal and the state level, and what we may actually get. Because again, fiscal people are going to see this expanding policy, you're costing me more, and we don't have the money or we don't want to spend the money. So that's definitely going to be a factor in what we see going forward in 2024 and beyond that as well too. So that is it. Again, that's the CCHP website. We also have a newsletter that you might want to subscribe to, especially if you want to know a little bit more about that court case. That is going to be like the topic of our next edition that comes out on Tuesday. And with that, I have a little bit of time to take some questions. So I'm going to go into the Q&A here just to see what you guys are asking. So I'm just going to go down from go top down. First is from Anonymous. A Medicare documentation required for telehealth is too onerous. Medicare could recoup 100% of our audited claims, saying the office did not meet requirements. We now no longer plan to offer any telehealth appointments. How shall we navigate this without inconvenience to our patients? I'm not sure that there's a question there. Again, like the documentation of what they were asking for, that is something that you can try to have a conversation with CMS, and also particularly like what exactly did they say in your audit as far as, that they can claim that you did not meet their requirements. And we'd like take a closer look at that as well too, to see exactly what was their issue on like the documentation that you lacked or did not meet like their requirements there or their specifications. Will private Medicaid providers be eligible? I'm not sure what that's referring to. I think if you're talking about Medicaid, you're going to have to check with the individual state. I'm not sure what you mean, like eligible for what. So if you're talking whether the Medicaid provider would be eligible for Medicaid reimbursement for a particular state, some states, again, they do have like a limited list of eligible providers. So for any Medicaid program, a provider would actually need to become like a Medicaid provider to begin with. So there's not necessarily like, a separate category if you do things via telehealth. You're just going to have to become a Medicaid provider to begin with. And then depending on the Medicaid program, you'll have to see like what providers they will allow to use telehealth to provide the services and that they will reimburse. So that's actually kind of step is that a provider would need to become a Medicaid enrolled provider with that state Medicaid program. And then you would need to check to see if like that type of provider, whether they would qualify or whether their services are actually allowed to be provided via telehealth underneath that Medicaid program and their policies. Do you need to follow Medicare guidelines if you don't bill Medicare and provides super bills for their patients? So You need to follow Medicare if you are intending to, if your patient is being covered by Medicare and you are intending to seek reimbursement from them. If your patient is covered by a private payer plan, then you would need to follow like that private payer's policies. If they're paying out of pocket, no, you don't need to follow the Medicare policies on that. You would probably need to follow, you wouldn't need to follow any state policies. So there may be state policies around certain things such as, for example, licensure. So there are certain policies that still impact you, maybe not necessarily on the reimbursement side, but if you're not billing Medicare, you're not needing to follow those Medicare policies. So it depends on like how payments being made. What are your thoughts on CMS assertion that video telehealth doesn't fulfill statutory requirements for equivalency to in-person visit? So I don't think they've made that assertion. I think what you may be referring to is that certain services they say are not comparable to in-person. So I think this is what the questioner is asking about, is that when I said earlier that actually the eligible services underneath Medicare, that's actually kind of underneath more underneath CMS's discretion to do rather than for them having to wait for Congress to do anything. They have a certain protocol and how they approve those services. And those are certain like levels of what they say would qualify. And one of those is showing that it has like, you know, equivalency to like in-person. I think that's what the questioner might be asking about. And, you know, that's the setup that they've had there. So that's like the requirements that they've like, you know, gone with. And they actually changed the process with the last year's physician fee schedule. So if there were concerns about that, that was the time to like, you know, raise those concerns of like them changing the process and what they were requiring. I think that's what the person's referring to. Ray Rao, if that's not what you're referring to, please go ahead and like, you know, put a follow-up question there. For supervision and residents, I was under impression that virtual supervision for Medicare patients remains available. For instance, in-person consult can't be staffed with HIPAA compliant telehealth, where attending provides medical decision-making purposes. Yes, I was talking about residents. Earlier, I was talking about supervision of the residents there. There are some supervisory allowances via telehealth that are still there. Again, I would go to some of those resources that I put in the link. If you're able to just to like download a copy of this PowerPoint, you'll be able to see that. Do established patients need an in-person visit prior to the end of 2024 to continue medication management? So the in-person visit requirement is regarding that I was talking about earlier was related to prescribing controlled substance. So Amanda, are you asking about Medicare? Are they requiring it? So it depends on where you're talking about. So it's going to depend on like where and what you're talking about. If there's a controlled substance involved, we're not sure yet. We're not sure what the DA is going to require. But if you're also, it's going to depend on like, you know, who you're talking about. You're talking about Medicare or Medicaid and whether they're requirement. In general, yeah, if you could be more specific, Amanda, that would be helpful. We're starting to run out of time, so I'm just going to take one more question that's here, and then I have to turn it back to Aria. Can controlled substances be prescribed by audio only, or does it have to be video audio? So right now, the controlled substance, there is an exception for buprenorphine. It's a very, very limited exception. It's an exception that was in place from the COVID-19 pandemic. I think it's still in place. It was something that Samson, the DEA, agreed to, and I think it is still applicable right now. Again, it is only for buprenorphine, and there's like other requirements around it. So it's a highly specific situation there. And that is, if you want to reach out to me, I don't have time to go into it right now. I can like give you like that, the parameters that they have there. But for the most part, it's no. Except for like this highly, highly specific scenario that they carved out. But right now, I'm sorry, I know there's a lot more questions, but I need to turn it back to Aria because we're out of time here.
Thank you, May. Just a reminder that our next webinar will be held on Wednesday, February 21st. That webinar has been rescheduled from our regular third Thursday cycle. It's going to be hosted by the Mid-Atlantic Telehealth Resource Center. Registration information is available on the NCTRC events page. And then lastly, we do ask that you take a few short minutes to complete the survey that will pop up at the conclusion of this webinar. Your feedback is very valuable to us. We will download the Q&A and I'll send that over to May and the CCHP team. Thank you again to May for her presentation today, and thank you to the Center for Connected Health Policy for hosting today's webinar. Have a great day, everyone.